An employment contract is a written agreement between an employee and the employer. It outlines the conditions of the employment and helps protect the rights of both the employee and the employer. If there is a misunderstanding between an employee and the employer over the job or duties, one is expected to refer to the contract. According to Anne Babu, an advocate of the High Court of Kenya, the Employment Act, a written contract should have specific particulars such as name of the employer, job description, date of commencement of the employment, type of contract, and duration of the contract. Other details include hours of work, remuneration, annual leave entitlement, termination notice period, disciplinary rules, sick leave entitlement, and sick leave pay, and any applicable pensions. Section 10(3)(6) of the Employment Act requires that an employer keeps the particulars of an employment for 5 years after termination of the employment.
And that they are kept. Those records may also be necessary for purposes of reference. When the employee leaves that employment, there could be another employer that may want to check the records of that particular employee. So it will be important that they then write to the former employee to ask for a reference. So if there are no records and maybe the management has changed, then it becomes difficult to get that employee's records. So it is important that the employer keeps the records. And it's an offense, criminal, and it is punishable if an employee does not keep the records.
It is the employer's responsibility to prove that an employee was aware of the existence of the documents and agreed to be bound by their terms.
An employee can still go to court just as much as an employer can go to court. Either of the parties can go to court, even if the contract is still subsisting. Equally, the employer, and this happens, you have seen the state through TSC approaching court to obtain an injunction to restrain teachers from proceeding on a strike. So even the employer has a right to go to court and stop the employee from, say, withdrawing labor.
The employer should therefore have an acknowledgement signed by the employee confirming these two details. The employee should either be given copies of each of the documents not later than 2 months after the beginning of the employment, or should have reasonable access to them, such as the company's website. The Employment and Labor Relations Court has in past instances held that an employer who fails to issue a compliant contract exposes himself because, in the absence of the evidence to the contrary, the court will accept and adopt the employee's position. Dzuya Walter, Business Insight.